Good evening. I want to welcome you to the campus of Lipscomb University. My name is Bob Wood. I'm a partner at the law firm of Bradley, Arant, Bolt Cummings here in our Nashville office, and have the privilege of being a part of the Board of Trustees here at Lipscomb, and really excited about tonight and wanted to just take a moment to welcome each of you here this evening. Glad you're being a part of this conversation, and particularly say thank you to Justice Koch for joining us for this conversation of significance. Several years ago, this university, through the Institute of Law, Justice, and Society, began this series entitled Conversations of Significance. And those conversations are designed not only to engage our community, our academic community, in significant discussions, but also our Nashville community, our greater Nashville community. And quite honestly, one of the things that I've been just thrilled to be a part of and actually kind of watch from the sidelines as a board member is the great things that we've experienced here at Lipscomb over the last 10 years as President Lowry has brought a breath of fresh leadership to the university and really given the campus and the university a sense of what it really means to be a part of community. And we're excited about those things and the things that are going on. And I think our Institute for Law, Justice, and Society reflects that, and what's going on here this evening reflects that. So again, thank you for being here this evening. Justice Koch especially, thank you. We look forward to hearing from you. So with that, I would like to turn it over to the Director of the Institute, Randy Spivey. Thanks.
As Bob said, my name is Randy Spivey, and I am the Director of the Institute for Law, Justice, and Society here at Lipscomb. And this is one of my favorite things to do, to get to have these conversations. We've hosted a number of people from White House staffers to recently exonerated folks from Tennessee's death row. We've had conversations about understaffed public defenders and about the need for interfaith dialogue. And I am so excited to welcome Justice Koch into that deep and rich conversation that we've had tonight. I believe most of you know Justice Koch, but I think it's really important to sit down and go through his career a little bit as we begin, just to kind of get a sense of where the conversation goes tonight. So he began his legal career in 1972 after graduating from Vanderbilt and becoming an assistant attorney general. In 1977, Attorney General Brooks McLemore promoted him to Deputy Attorney General, a position he held until he became Governor Lamar Alexander's legal advisor in 1979. He later served as Commissioner of Personnel under Governor Alexander, and in 1981, Governor Alexander named Justice Koch counsel to the governor. In 1984, Governor Alexander appointed him to the Court of Appeals, where he served for 23 years, the last 3 as presiding judge of the middle section. And in June 2007, Governor Bredesen appointed Justice Koch to the Tennessee Supreme Court, one of the few justices who have been appointed by both a Republican and a Democrat. He served on the Tennessee Supreme Court until last week, when he then became and is currently the new dean of the Nashville School of Law. But I think his influence has spread much further than just his time on the bench throughout the Nashville and Tennessee community. His commitment to legal reflection is reflected in the role he's played in the growth of the American Inns of Court here in Tennessee and nationally. He has taught at Vanderbilt University, at that other law school down the road, and also he's taught constitutional law at the Nashville School of Law for 27 years. Is that right?
17.
17. That's a little different.
To some of the students, it
feels like that. In 2002, he was named the Tennessee Appellate Judge of the Year by the American Board of Trial Advocates. In 2006, he was recognized as one of the 500 leading judges in the United States. And in 1999, he received the Dr. Thomas F. Frisch Jr. Excellence in Volunteer Leadership Award from the United Way of Metropolitan Nashville. Please welcome Justice Koch to Lipscomb. I've been looking forward to this for some time because unlike the other times we have been together, I get to ask you questions tonight.
I know
And that is something that I relish. So let's start with what you've been doing for the past week, which is the Dean of the Nashville School of Law. You're leaving the court to become dean. Seems to me more of a transition than a retirement. Why make that decision now? And why leave the court now to move on to the Nashville School of Law?
Well, and thank you for your generous introduction. I appreciate that. And when we have transitions in our lives, there are different mechanical procedures you use to accomplish that. And my transition necessarily had to be through a, quote, retirement. There are a lot of folks, when they heard that, stop and say, well, what sunny beach are you going to be resting on? Are you going to be kicking back and enjoying life? And the answer to the first is, I'm not going to be resting on a sunny beach. Number two is, I am going to be enjoying life, but I'm going to be enjoying life in the final chapter of my legal career, and that is to be the Dean of the Nashville School of Law. And you asked me what I've done in the last week, and that's actually a tough question to answer because, as we'll probably talk about later, I have a wonderful staff at the Nashville School of Law. They support me very well, and they gave me permission to spend all this week traveling to 17 different cities in Middle Tennessee to explain to our fellow Tennesseans why the judicial elections that will be held on August 7th are so important. But I have been able, since I've started, to get ready for our entry class of the first-year students in the Cooper term. Their legal career will start on the 7th of August. It's not too far away. The courses are ready. The teachers are ready. They're excited and a little bit afraid. I'm excited and a little bit afraid. So we're getting ready for another school year. My first one is dean, and I'm very excited about that.
What is it that attracted you about the Nashville School of Law? The Supreme Court is that's a nice gig. And I think very few people would walk away from that to something like this. What attracted you about that challenge?
I would have been very happy staying on the Tennessee Supreme Court. I love that work. It's something that I've enjoyed doing ever since I became an appellate judge. And pragmatically, had I stayed, I would have been the Chief Justice of the Tennessee Supreme Court on September 1st. And all that would have been well and good. And I guess on my tombstone, they could have said Chief Justice William Koch, for whatever good that would be. I've been teaching for a long time. And to me, the future of the law rests in the hands of the students that we are preparing to enter that profession. And the United States and Tennessee is still a work in progress. We're not perfect yet. We never will be, but our aspiration is to get better. My generation of lawyers and the generation that preceded me did their utmost to honor the principles of equal justice under law, fundamental fairness, and the honor of playing a small role in preparing the next generation of lawyers who are going to pick up that baton, a number of whom are in the audience tonight. I finally realized there was no higher calling that I could have than doing that. So while I value every minute I served on the appellate courts and on the Supreme Courts, when the Board of Trustees, two of whom are here tonight, so I'm going to mind my manners, suggested that maybe I ought to consider the Nashville School of Law, the light bulb went over my head, and I said, what more important thing could you do?
So will you continue to teach?
I will continue to teach. Being in the classroom with the students keeps me on my toes, and for those of you that are teachers, you understand what that means. Fresh ideas challenge your conceived notions about your subject matter. And so I will keep teaching. That was actually the second condition in my contract discussions with the board, that they would allow me to keep teaching, and they agreed to that.
What do you see as the place in the Nashville and broader Tennessee community for the Nashville School of Law?
I can give you my vision of where I think it is. I'm the kind of person that likes to tell people what I've done rather than what I'm going to do. So in terms of what is going to unfold in the future at the school, that's a work in progress. Our school, the National School of Law, has been in existence for 103 years. And all of us that have been associated with that school are very, very proud of it. As a matter of fact, we're proud enough about it that shameless self-promotion on the table to my right are books about the history of the National School of Law, and they're welcome to any of you without charge. For any of you that want to learn more about the school, pick up one of those books on your way out. It's called Profile in Tenacity, and that sums up the mission of our school. We have been a very important institution in Tennessee, but a very much unheralded one. Our graduates have gone on to distinguished careers in government and the private sector. We have an alumnus who is a United States Senator. We have prosecutors currently that are our graduates. Public defenders are graduates. Right now, 4 members of the General Assembly go to the National School of Law as students. We have physicians, musicians. We have a very eclectic group of persons who have decided to be challenged by studying law for 4 years at night, in addition to juggling their demands of their jobs, the demands of their family. And I am very proud of that school. The role that I see we're going to play is to really, number one, increase our visibility, to realize that we are a community resource, not just for students that want to come study law. We can be a community resource for the public in general that want to understand the legal system better. We have a very complicated system that many folks who have not studied law don't understand. I hope that we can become a place where the legal profession and laypersons can come to a better understanding about how the law fits into their lives. I see us being able to provide continuing education for lawyers in a novel and new way. There may be some distance learning in our future. So I think that our school's role is going to be carried as far as the faculty and the students want it carried, and I'm going to be the facilitator for that.
The Supreme Court, while you've been part of that panel, has really focused interest on the Access to Justice initiative. It seems to me the National School of Law holds a really unique place in the legal community, specifically because it is inexpensive and provides different kind of access to that. Do you see a connection in your mission and access to justice in Tennessee?
That's a great question, and the answer is absolutely, and it was really one of the most significant reasons why I accepted the board's invitation to join the school. Many of you know that our court 5 or 6 years ago announced that our chief public policy initiative, other than our adjudicative responsibilities, was to promote access to justice in Tennessee. What we know, it's beyond reasonable debate that there are many of our fellow Tennesseans who simply cannot afford a lawyer and are knocking on the door of the court seeking fairness and justice, and it's difficult for them to get it. We rely on the legal services folks who do yeoman's work, but their reach in terms of how many cases they can handle are limited. Our private bar does more pro bono work than many people realize. Now we're aggressively publicizing how much pro bono work the private bar does. There is still a gulf of unmet needs. And what I know about our students at the National School of Law is that most of them choose a profession where they're going to practice retail law. They're not going to go to Wall Street and do 10b-5 work, although that's wonderful, challenging work. They're not going to be antitrust litigators in Washington, D.C., although that's great work too. They're not going to do mergers and acquisitions. But as I've seen demonstrated over this last week, being out in 17 cities and seeing our graduates, they do everything. They're going to write the will for the folks. They're going to go over the mortgage contract. If the son or daughter or cousin has gotten a scrape, they're going to get a lawyer. The lawyer's going to handle the problem in criminal court. If there's a contract issue, they're practicing general country square law. We need that very badly. And it's ironic that the most underserved class is the lower middle class, where they do not qualify for government-assisted services, but they cannot afford what many lawyers charge. Well, it's the lawyers on the courthouse square that can provide quality services for reasonable rates, and that's the sweet spot for our graduates.
Judge Lozier left a tremendous imprint on the Nashville School of Law, from an incredible growth in reputation and size and facilities. When this chapter is over for you, what would you like that imprint to be?
I don't think I get to dictate what that imprint is. As you were asking that question, I was thinking of an oath that physicians take, and that is do no harm. So I'm going to set my standards a little bit higher, but I hope that if the faculty and the students and the alumni and I are successful, whenever it's time for me to pass the baton to someone else, that what they'll say is that the door of opportunity was opened wider while he was there. And there were more students, more diverse students that had an opportunity to study law, that the school added value in other areas. But it won't be me doing it. It'll be the faculty, the students, and the alumni doing it. And if I get to bask in their glory, that'll be fine.
All right, very difficult question. Do you prefer Dean Koch now or Justice Koch?
Well, my wife and I are having that argument. I don't know, my first name keeps getting changed. Senator Douglas Henry, a good friend of mine, still calls me General Koch. I kind of like that, the way that sounds. If for those of you that have been out to the Hermitage, and if you haven't been out there recently, I suggest that you hurry up and get out there. If you look at Andrew Jackson's tomb, it does not have President Jackson subscribed on it. It has General Jackson. He preferred that. So, but only Senator Henry calls me General now. I like Bill a lot. There are some people that just can't bring themselves to do that. Around the house, it's hey you. That's not fair. I apologize. I apologize. If Bill's not going to work, I'm Dean right now, so I guess I'll be Dean for a while.
Just so all of you know, there are note cards that students are going to be passing around with pens in case you have any questions for Justice Koch. There'll be a time at the end where we can, you can have a chance to enjoy what I'm enjoying right now, which is asking him questions. So to move from the Nashville School of Law to your judicial career, you were appointed to the Court of Appeals and later to the Supreme Court. Has it been what you expected?
I would have to say pretty much. I mean, most of my legal career when I was practicing was as an appellate lawyer. And I think by the time I moved on to other work, I had argued about 750 cases on appeal. So the appellate courtroom was a very comfortable place for me. That's where I had spent a great deal of time. The transition from one side of the bench to the other is a challenge, I think, for anyone, as the judges in this room would admit. And the most significant challenge is that society, when you become a judge, places a distance between you and them. You know, your friends at the bar that you had before are reticent to be seen with you, not because they don't like you, but they're concerned that others are going to think they're playing up to the judge. So in many ways, a judicial career is a monastic one. There's some people that don't like that, and they don't stay that long. They want the hurly-burly of the marketplace and the courthouse, and they do a good job, and then they decide they want to do something else. Personally, for me, I like that kind of work. That I like sitting in my office reading my dusty books and trying to count how many angels dance on the head of a pen. And I was able finally to master a keyboard, so I don't use my fountain pen and a legal pad anymore. I can actually type the opinions out. And I like the challenge of taking raw material, facts and law, and figuring out how they connect together in a coherent, logical way, and then trying to explain that in writing to a readership, many of whom are not going to like what I'm saying. Certainly the losing party is not going to be overjoyed when they read the opinion. But to write it in a way where people will be able to say, I understand how he got from A to B to C to D. I may not agree with how he got from C to D, but I understand what was in his head when he did it. And I just enjoy that challenge. It's a constant battle with the English language. And for any of you that are at the bar or any of you that write anyway, you know, there's some days where English is your friend. There are other days when it's like holding a gun to your head. I like that challenge. So that is part of the life of an appellate judge that I have liked a lot. I'll be still doing some legal writing as dean. I'm going to be doing a lot more different things, and I'm looking forward to that too.
Is that how you've seen your role as a jurist, is taking the raw material, as you say, and creating a narrative between the two? Yeah, I've heard you talk about this a couple of times, where writing seems to be central into how you approached being a judge. Was it that way from the beginning at the Court of Appeals?
It was. For those of you all that are in law school, have been to law school, I'm sure you remember when you were first exposed to the great cases that were written 150 years ago. And you would read that jargon in that wonderful Victorian way they would write, and you'd say, well, I think I know what the court's saying. And then you'd go to class and your professor would start explaining what the court was saying, and you're saying, gee, that's not the same case I read last night. And so the transaction of ideas to paper, to me, is a central part of what an appellate judge does. Now, a general sessions judge doesn't do that. Trial judges do that to a much more limited degree, but appellate judges' job is to be careful stewards of the law. And the way we're careful stewards of the law is that we write opinions that become part of the fabric of the common law. They are the opinions that lawyers like Greg Ramos read in order to tell their client, if you do that, you can, but here's probably what's going to happen. And unless a court, a multi-judge court, writes an opinion in a way that gives the lawyers the ability to predict what the court's going to do in similar situations down the road, we haven't done our job. And the way we do that is through plain, concise writing. Now, I confess, my writing's not always known to be concise, but I hope that it's at least plain.
It's okay to say amen for those of you who have read it.
But writing to me is a central task that appellate judges have.
So you said something when we met last week that stuck in my head, and when you said it, it did not process through my mind immediately, and so I didn't ask you about it, but I'm going to ask you about it now. Your senior year in college, you spent the entire last semester or the entire year?
Entire year.
Reading all the works of Faulkner. I don't really know that I have a question.
Well,
other than to ask, I mean, with what you're talking about now, it seems very early on that there was a centrality to narrative and a centrality to some degree, storytelling that was inherent in how you approach the law. Where did that come from?
I'm sure we all know about the Imagination Library. It's a wonderful program where children between the time they're born and their 5th year get free books. I had an imagination library when I grew up. It was my grandmother. And every night she would read to me for an hour or so until she was hoarse. And she wouldn't read me children's books. She'd read me Greek mythology and Tanglewood Tales and just wonderful old things. And it forced me to think about the power of story. And what I learned after practicing law a while, and actually one of my teachers was Lamar Alexander, is that lawyers tell stories. If we're in front of a jury, the prosecutor is telling a story about the terrible thing that the defendant did. The defendant is telling the jury a story about what forces in the person's life either put him or her in that situation, or another story to say, well, they got the wrong person. So law is a profession of stories. Legal principles don't exist in a vacuum. What an appellate judge and what lawyers know is that we have books filled with legal principles. But legal principles only take life when they're connected with facts. Facts are the story. So then the question becomes, if I am writing an opinion, I am actually engaged in a process of persuasion. I am trying to persuade anyone who reads my opinion that I reach the right result. So how do I do that? Well, I can write, if I were to write like William Faulkner or James Joyce, for any of you that have tried to get through Ulysses a time or two, it's heavy lifting, right? You don't get it on the first time. You don't get it on the 10th time sometimes. So the writing is different. For legal writing, we can't write poetry because we have to mean one thing, not 10. And the challenge of doing that in a way where you do it by telling a story. Let me give you a quick example. Let's say we had a hypothetical case about a retired teacher. She's 86 years old. She's got gray hair. Her husband has died. Her only thing she owns is her little house by the road. And one day, a fast-talking storm door salesman comes by and convinces her to completely clad her house in aluminum siding and just tells her this is all going to be great, has her sign a contract that basically now gives him a mortgage on her house. And he's told her all this stuff about how inexpensive it's going to be, but she signs the contract without realizing that the monthly payments for that work are going to be far more than she can pay. Right? That's the facts. Now think about, as a lawyer, how you would tell that story. If I'm the lawyer representing the widow, I'm going to tell the story in kind of the way I started out. We have an elderly widow. She was a retired teacher. She had very little money. That she had the only asset that she had was her husband's house that she lived in, and I'm going to tell that story in a way where the reader is going to be tilted in the widow's favor, right? Now, if I'm representing the aluminum storm door salesman, I'm not going to mention her name. I'm not going to talk about Ms. Smith. I'm not going to talk about the fact she's a retired teacher. I'm going to use a generic term. I'm going to say the purchaser bought improvements to her house and signed a contract that plainly stated what the cost was and what the payments would be, and period. And the contract's a contract, and that's the end of it. Well, as a judge, when I'm going to decide that case, and actually Abe Fortas, justice on the U.S. Supreme Court, was a master at this, I can tell the facts correctly in a way that's consistent with my opinion. So if my opinion is going to be to side with the widow, I'm going to say something like, this case is about Ethel May Yazell of Tullahoma, Tennessee, who saved her money and in her retirement got caught in the clutches of a fast-talking salesman. All that's going to be true. Those are facts that are in the record, but I'm telling that story in a way when I get to the facts, when I get to the legal discussion, the facts and the law are going to be synergistic. Rather than just saying purchaser, buyer, this, that, lawyers can use the facts to be persuasive, and the way they do that is to tell the story. And that's why I think that's so important.
You mentioned Governor Alexander, and I'm sure there's a lot of really great stories surrounding your relationship with him, but one colloquially known as the coup in Tennessee, you were intimately involved in. So tell us a little bit about your involvement in that situation when Governor Alexander was sworn in prior to the end of Governor Blanton's term, and what lessons you took from your involvement in that.
Well, I will tell you one thing. For many years after the events of January 1979, the word coup was embargoed. We didn't refer to that as a coup. It sounded a little bit too revolutionary, but Keel Hunt got the license to use the word coup, so coup's fine.
It sounds really fun.
Well, yeah, you ought to do a coup sometime.
Yeah.
Yeah.
I think I haven't tried.
Yeah, and yeah, that's right. And the statute of limitations is run, so I can safely talk about all this now. Our Tennessee Constitution, like many state constitutions, has a provision that basically says that when the government is being unjust and not serving the needs of people, the people can take the government back and reform it. And we had an unfortunate situation between 1975 and 1979 where we had a governor who did not know where the boundaries were and ended up abusing his power. And one of the ways that he was abusing it was threatening to grant wholesale pardons to persons who didn't deserve executive clemency. Well, that presents a pretty difficult legal problem because under our Constitution, the governor's clemency power is unrestrained. The legislature cannot second guess it, the courts cannot second guess it, but an abuse of power, even if it cannot be checked by other branches of government, is still an abuse of power. So there was a crescendo of events that ended up in January of 1979 where Governor Blanton, late one night at the Capitol on the 15th of January, pardoned 52 people. One of those, a lot of serious criminals in that group, but one of those persons had killed his former wife and his wife's and her boyfriend by shooting them 18 times with a 2-shot Derringer. So for those of you prosecutors in the room, it was not hard to prove premeditation there. You had to reload 9 times before they were finished. And so he was convicted by a jury of his peers in Johnson City and was sentenced to 40 or 60 years in the penitentiary. He happened to be the son of one of Governor Blanton's political cronies. And so as soon as he got to Nashville, the governor decided that he shouldn't stay in prison. He named him a trustee, designated him as the state photographer, gave him a camera and a car, and Roger Humphreys was out just having a big time. Unfortunately, people discovered this, and the citizens of the state erupted. And when the governor pardoned him that night, along with 51 other people, the citizens and the political establishment on both sides of the aisle, Democrat and Republican, were revulsed. So the question became what to do about it. And as it turned out, our law at that time allowed a person to take the oath as governor as long as 2 conditions were met. The first was that the election had been certified by the Secretary of State, And secondly, that the date was on or after the 15th of January, because the law at that time measured the governor's term from the 15th of January to the 15th of January 4 years later. And so there was an attorney general's opinion that had gone without notice for many months that had said, well, you can swear the governor in early. So after Governor Blanton let all these people out of prison, the question came to the fore, well, why don't we swear Alexander in early? Well, Governor-elect Alexander tried to quell that discussion by saying, I'll have nothing to do with that. That's not the way we have governmental transitions in this country. That was on Tuesday. On Wednesday, the U.S. attorney, at great personal and professional risk, without talking with the Attorney General of the United States, called Governor-elect Alexander and said, I have reason to believe that the governor is about to execute more pardons. A number of those pardons are for people who have paid their way out of prison. And so the only way that this can be stopped is for you to take the oath early. And the U.S. Attorney, Hal Hardin, says, I'm calling you not as the U.S. Attorney, I'm calling you as a concerned citizen. This has to be stopped. And I'll compress what happened that day, but eventually Governor Wilder and Governor McWhorter agreed. The Chief Justice at the time, Joe Henry, agreed to administer the oath. And at 5 o'clock on the afternoon of the 17th of January, the constitutional officers, the governor-elect, the legislative leaders, other prominent Nashvillians assembled in the courtroom, and Governor Alexander took the oath 3 days early to prevent the governor from issuing more pardons. In fact, when we secured the governor's lawyer's office right after that ceremony, the governor's new lawyer was in the office with a stack of pardon papers, and in fact, a number of those pardons were linked to individuals who had bought their way out of prison. So the lesson that I learned from that as an observer is this. It's really two lessons. The first one was that I was not an intimate of Lamar Alexander. I only knew Governor Alexander by opposing him in court. I had been on other sides of lawsuits with him. He had had the trust in me to ask me to come be his legal advisor, not because I was his best friend, but because I guess he thought I was a halfway decent lawyer. But I watched Alexander through that process, and I also watched Speaker McWhorter and Lieutenant Governor Wilder. And through that process, the three of them facing that challenge together at the beginning of a new governor's term provided a level of trust and confidence between the three of them that ended up coloring Governor Alexander's entire career as governor. And one of the most important commodities in public service are for public officials to trust each other. Trust is in relatively short supply these days. Back then, the trust between Alexander and McWhorter and Wilder for successfully addressing that problem created by Governor Blanton set the tone for the Alexander administration. After Governor Alexander left office, McWhorter became governor. It set the tone for that relationship between the Democratic governor and the Republicans in the House and Senate, and really, I think, created stability at the government level for a number of years after it happened. So that was, the first lesson was that officials who trust each other enough to face difficult decisions work together better. The second thing I learned is this, and I'm not from here, so I've had to learn about Tennessee since I came to law school. But what I learned was this, that at the end of that early swearing in, the media is getting comments from the people in the room, and my good friend John J. Hooker is commenting at great length, and different dignitaries are commenting at great length. And at the end of the evening, Hank Allison, the reporter, wants to ask Ned McWhorter, then the Speaker of the House, one last question. And the question was essentially this. He said, Mr. Speaker, I can't help but notice that virtually everyone in this room are Democrats. You've come together to swear in a Republican. What do you have to say about that? And like a very adroit public official, which McWhirter was, he gave Allison a non-answer answer. You know, we all go to school in public life to learn how not to answer a question. And McWhirter did a great job with that. Usually reporters, unlike you, who are a good cross-examiner, usually reporters just give up and go on to the next question. But on this occasion, Allison said, "Governor, good answer, but that was not my question." And so McWhirter says, "Well, ask your question again." So Allison starts into the question again. He says, he's holding the microphone up. He says, "I can't help but notice that most of the people in this room are Democrats and Alexander is a Republican." And McWhirter said, "Stop." He said, "We're Tennesseans. I'm a Tennessean first, and this is good for the state regardless of the party." The only thing that Hank Allison could say was, "Thank you, Mr. Speaker." That was the end of it. And, and that's the other thing I learned. We are all Tennesseans first. Politics is important. Some of us pursue it as a vocation, some as an avocation. It certainly makes good reading in the morning paper, and all that's great. But Tennessee has had a tradition of its public officials playing the political game, but when it came down to do the work, they do the work. And that's what Ned McWhirter was telling folks that night. We're all Tennesseans first, and this is what was good for Tennessee regardless of the party. And that has shaped my idea about whatever life I've had in politics or in public life, that, you know, I have personal beliefs, and I have strong opinions, and I have political persuasions. We all do in this room. But eventually, if we're going to do the public good, we put that down, and we use the C word. It's called compromise. It's the D word, dialogue, and the R word, respect. And I saw that in spades in January of 1979. It's harder to find that these days, I think.
Well, let's talk about these days a little bit. Much has been made recently about the way Tennessee selects its appellate judges. August 7th, the retention of 19 appellate judges and 3 of your colleagues on the Supreme Court will be voted on. What should Tennessee voters know about the judicial selection process and those 22 judges as they go to the polls on the 7th?
Well, if anybody tells them there's a perfect way to select and retain judges, don't believe it. If anybody wants to tell the people that there is a non-political, small p way to select judges, don't believe it. You know, this is a human endeavor. But here's what the people of this state need to know, that in 1971, our legislature, exercising its clear authority under the Constitution, decided that appellate judges and trial judges were different. Trial judges, people in their community know they're trial judges. You know, they know who they are. They may go to church with them. They may have kids in school with them. Trial judges are known commodities, so the way they're selected works very well. They have either nonpartisan elections or partisan contested elections. But appellate judges are essentially invisible. If you were to ask the members of the Tennessee Bar to name all 5 members of the Tennessee Supreme Court, my guess is that 25% might get 3 out of 5. And that's not because they're not informed. It's just because they're not in the Supreme Court that much. They may do transactional work. They don't pay attention to that. It's a similar phenomenon in the United States Supreme Court that while 75% of the public can name the 3 judges on American Idol, 30% of the public can name 2 members of the United States Supreme Court. So what that tells me is we're kind of an invisible bunch of judges. So the question becomes, we want to preserve the people's right to hold their judges accountable through election. How do we do that when the people do not know who these appellate judges are? And what the legislature devised back in the middle 90s, which makes a lot of sense, is we have an evaluation process. That evaluation is not run by the courts. The evaluators are not selected by the courts, but these evaluators are intended to review our record, review our decisions, review our demeanor on the bench. Do we show that we're any bias or prejudice? Are we punctual? Are we courteous? Do we render our opinions on time? They read our opinions to decide whether they're clear or not clear. And then this group that consists of laypersons, lawyers, and trial judges grade the appellate courts. And under the way our system works, if we don't get a passing grade, if a majority of the evaluators say this person should not be allowed to serve, then our name can't be on the ballot. You know, we're gone. Or we cannot run for a retention election. We can, if we're foolhardy enough to continue to soldier on after this group has said you're not doing a good job, then somebody can qualify and run against us. Well, all 22 members of the appellate court that are going to be on the ballot on the 7th of August have gone through this evaluation process. And every single one of them has found, by significant majorities, to be eligible and to be competent to serve for another term. That to me is the good housekeeping seal of approval. Now I'm in a privileged position. I've read these judges' work. I know these judges. So I, unlike a lot of people, can make an independent decision based on direct knowledge. I can tell you that the Evaluation Commission got it right. All 22 of these judges deserve to be retained and deserve an opportunity to stay in office. So what I would like the public to know is these judges have been carefully scrutinized. They've been put under a microscope. They have been asked hard questions, harder perhaps than what I'm getting tonight by the evaluators. The public's been allowed to come in and say good things about them and bad things about them. And so they've been vetted and tested, and a group of persons who took an oath that they were going to approach this job professionally and competently have found that they're qualified. Some of you, if you read the morning paper, you might have seen an op-ed piece by one of the evaluators, one of the toughest questioners, by the way, in the evaluation process, who is very upset about the slurs that are being made about the process. And what he was telling everyone today is we took this very seriously. This was not the fox guarding the chickens. We worked these judges over pretty good, and we found that they are eligible to be retained. So I would hope that voters would say a group of people just like us have evaluated these folks. They have found to be doing a competent, good job. They ought to be retained. And I think if most Tennesseans understand that, they would say, well, that's good enough for me. Some people have looked out after my interests, think they're doing a good job. But normally that's worked fine, but this is not a normal year.
Why has it become so contentious?
Why has it become so contentious?
Is that a hard enough question for you?
Now you're getting it. I'm going to try to give you a shorter answer than what I've been giving, and I apologize if I've been rambling. I'm going to give you a short answer that explains it. Absolute power corrupts absolutely. That's a theorem of political science that I believe has been borne over to be true since recorded history. The persons who wrote our Constitution understood that. The persons who wrote the United States Constitution understood it, that the concentration of government power in the hands of one or a few leads to an erosion of our rights and liberties. So they came up with a little doctrine that most of us probably encountered in the 5th or 6th grade. It's not taught that much in schools today. It's called separation of powers. They separated the powers and prerogatives of the different branches of government to protect the rights of the people from the sort of oppression that people had seen in England and in Europe and elsewhere in recorded history. What's going on today is that we have some at the levers of power who want more power. And one of the ways they want more power is, as one of them has said, I want to see judges who think just like me. And some of us say, no, wait a minute. Now, is that the kind of judiciary we want? You know, that it may be great for the person who is getting judges that think just like him, but you may not think like me. You may think differently. And it undermines what the purpose of our courts are. Our courts are open to anyone, whether they're the powerful or the powerless. It doesn't matter whether you're in the Rotary Club or the Kiwanis Club. It doesn't matter whether you're Jewish or in the Church of Christ. Unless those matters are relevant to the dispute at hand, everyone stands on the same ground when they're in front of a court. And when we start getting into a circumstance where persons in power are given the leverage to select judges that think like them, that starts to sound like we're concentrating power in a very dangerous way. And so when my former colleagues asked me, would I go around and express my concern to folks, now that I can ethically do that, up until last week I could not ethically talk about this because judges are constrained in what we say, I said sure. So since Monday I've been to 17 cities having this discussion with folks in restaurants, in motel ballrooms, in lawyers' offices, talking about the fact that we are Tennesseans. We can take care of our own business. We should educate ourselves about these judges, and we should cast informed votes. And if we do that, I have no doubt that my three former colleagues, Connie Clark and Sharon Lee and Gary Wade, will be retained. And I would also expect that the 19 intermediate appellate judges, and I've said this for the last 3 days, I can say this now even if he's in the room, Judge Andy Bennett of the Court of Appeals, who is a legal scholar of the first magnitude, needs to be retained. So if anybody's looking for an endorsement, they've got mine. Now, do I agree with everything they do? No. Are they a big fan of everything I do? No. But what I know is that they have earned the trust and respect of their colleagues. Good friends and colleagues disagree all the time. I suspect many of you in the room have good friends where every once in a while you agree to disagree. But what I know is that these people approach their work with dedication, with professionalism, and with integrity. And I'm not going to be wearing a black robe anymore. I may end up finding myself in court one of these days. I hope not. But if I do, I want people like them hearing my case. There's no guarantee that I'll win, but I know they'll listen, they'll apply the law to the facts, and they'll render a fair judgment. What more can we ask for?
I'm going to ask Justice Koch 2 more questions. So if you have questions for him on your note cards, Neely and Corey will take those up now. In the past couple of weeks, well, in the past couple of years, really, there have been a number of rulings against the death penalty in a number of different states. The recent ruling by the federal court judge in California, as well as the problems with the execution last night. Given the problems with the lethal injection process, Tennessee's most recent law reactivating, I guess to some degree, the electric chair, what do you think the future of the death penalty is in Tennessee?
I appreciate the way you phrase that question. The Constitution prevents us as a society from imposing cruel and unusual punishment. Now, what that term means is elastic. In some parts of our history, some punishment was viewed as cruel and unusual, which today we would find barbaric. Under our Constitution, it is the people that decide whether a particular punishment is beyond the pale. And what our people acting through their elected representatives and senators have told us is that there are crimes that are sufficiently heinous for which the death penalty is warranted, and they've said that now there, in Tennessee there's an option of either using lethal injection or electrocution. The courts have said that either of those methods done correctly, and I know that might be an oxymoronic for some people, but both of those methods are not cruel and unusual. Certainly what's happened in several lethal injections lately with the new drug protocol are going to raise serious questions about the efficacy of those procedures. And I think that's going to be hotly debated. And there may be grounds, especially when an execution takes hours rather than minutes, and the accused person is writhing in agony while this is being carried out, that the courts are going to have to pay very close attention to that, decide whether that violates the state or federal constitutions. And so I don't know how that's going to come out. I have a concern about it. The California case, and I have not read all the opinion yet, I've been on the road, but the parts of it that I've looked at essentially say is that the death penalty is arbitrary because it takes too long between verdict and carrying it out. I would think most constitutional scholars are not going to accept that argument. Matter of fact, several noted conservative scholars have been quoted, have given statements that I've read in the last day and a half that just don't agree with that decision. So I think the future of the California court's decision, the legal future, is clouded. I do think that there is a good possibility that if we continue down the road we're going, the public is going to tire of this. And the public may say, you know, life without parole is a sufficient penalty for some of these heinous crimes. And when the public starts moving in that direction, their elected representatives will follow. Right now, if you poll Tennesseans, over 80% favor the death penalty. So we are not at that point yet, but you know, we may reach a point where the cost, and I would define that in financial terms, in human terms, in the suffering that the victims go through, the families that wait decades for sentences to be carried out, the limbo that they're in, the emotional cost of that may be so high that our citizens in Tennessee will say, if we can get a quick decision in a capital case where a person is going to spend life without the possibility of parole versus an incalculable delay in carrying out capital punishment, that our citizens may say, let's go with column A instead of column B. But that's going to be up for the people to decide.
What other issues do you see coming up very quickly on Tennessee's horizon?
There's going to be issues involving civil justice in the areas of tort reform and malpractice. Those legislation has moved through the General Assembly, and inevitably there'll be litigation over whether those are constitutional. Family life issues are going to become very important because the notion of family has changed. And you know, we no longer think about families solely in terms of mother and father and two children and a house and a picket fence and a dog and a cat. And so the complex family issues we're having now, whether it's beginning of life issues, end of life issues, parenting issues where we get into issues of surrogacy, the medical advances for infertile couples that want to have children of their own, that's creating a great amount of legal ambiguity in areas that significantly affect people's lives. Those are eventually going to go to the courts just to get final resolution. There are going to be issues about the right to vote. You know, there are efforts around the country, whether it's the photo ID bill or that sort of thing. So there are going to continue to be challenging issues, and the good news in my mind is that we have a court of competent, seasoned judges. My replacement, Jeff Bivens from Williamson County, is going to do a great job. Holly Kirby from Memphis, who's going to take Janice Holder's place, will do a great job. And so I think the law is in good hands.
As they come up to bring the questions, what are you reading right now?
Other than the blogs about the Supreme Court.
That's not healthy.
No, well, to me, the best modern writer in the mold of Faulkner is Pat Conroy. And I've got a couple of Pat Conroy books I haven't finished, but South of Broad is one that I'm working on. And then last week, our neighbors across the street, our friends, in celebration of my new gig, found me a book that was published in 1781 that are the memoirs of Roger Taney, who was a U.S. Supreme Court judge. And I'm looking forward to reading that. So those are the two that are on my bedside table.
Okay, first question. In your experience presiding over cases litigated by Tennessee lawyers, what has been the primary virtue you've observed in our bar, and what has been or is becoming its primary vice?
Look around the room who did that to you.
Not telling.
Yeah. Over the last 30 years, I would say that our bar has become better appellate advocates. There's now a tendency for more lawyers to appear more often rather than just occasionally. The bar is specializing in appeals. And so the art of presenting an appellate case, I think, has improved. And I think former Chief Justice Dewoda and Justice Bennett would agree with that. But there's also some bad news there. And the bad news, and we're getting back to that writing part, lawyers are more adept at academic communication rather than persuasive, succinct writing. And so I think that perhaps the biggest problem that appellate judges face is that we read a brief, I use that brief in quotes, that's 100 pages long, that can make points, the same points in probably 15 pages. So in some ways, I think the bad news is they need to make it more simple.
How do you, there's so many things that you hear from the outside and from parties to cases that have been before you, unintended consequences and things like that. So what are your thoughts on those who say that decisions made by the Tennessee Supreme Court have a negative effect on domestic violence victims?
We've actually had very few cases directly touching on the manner in which we address order of protection. Domestic violence is becoming a serious problem and has defied the solutions we've tried at this point. It'd be easier if I knew a particular case that the questioner was talking about, but I'm just not aware of any cases where we've made prosecuting those cases or getting orders of protection or providing folks the buffer they need between an abusive spouse or partner. I'm just not aware that we've made that more difficult. But if we have, I hope the lawyers will bring those cases back and ask us to look at them again.
Do you perceive a change in the Nashville School of Law and the American Bar Association's relationship?
Well, we are great fans of the American Bar Association.
I'm not sure that was the question.
There you go. There you go. Of course, what that means is, are you going to pursue ABA accreditation?
I believe that is correct.
Well, there. Okay. What I know is that if I wanted to pursue ABA accreditation, the two things would happen. One is the ABA is almost getting out of the accreditation business, so it is extremely difficult to succeed to get it. But if the Board of Trusts and I were wanting to pursue that, it would triple the tuition at the National School of Law. Our mission at the Nashville School of Law is to provide an excellent education at an affordable price. Our students today can get a law degree by studying with us for 4 years for what it costs to go to 1 semester at UT. Our students graduate without debt. Students at accredited schools borrow to go to school. It's not uncommon for debts to range from $75,000 to $120,000. They're entering a legal market today where the salaries that would enable them to comfortably repay those debts and live at the same time are getting harder and harder to find. So our mission doesn't require accreditation. We're training lawyers for Tennesseans. And as long as that's what our mission is, the only benefit that accreditation would give us is that our students could take the bar in other states. And while that would be a nice thing, I think the cost of accreditation is too high to want to do that right now.
What do you hope will be your greatest legacy as a Tennessee jurist?
I'm not competent to dictate that. I think persons' legacies are created by the people other than them. Although I have this vision of Dickens' Christmas Carol, and if you remember the character Marley, he's dragging around chains of his former life. So that's kind of the legacy I see right now. I've got all these chains that I'm dragging around. So if you don't mind, I'm going to beg off that and let you all decide what my legacy will be. And whatever it is, I'll accept it, wherever I am.
I want to thank you so much for joining us tonight. It has been a lot of fun for me.
Thank you.
So
It's been
much.
fun for me. Thank you.